lecture series Dato Seri Hishamudin Yunus, whom we respectfully refer to as judge at our office, and other prominent guest speakers will discuss about the interactions of public law and our private lives, and in particular, how public law safeguards the private citizens against the state. Each series will feature a different guest speaker. So today we have Dr. Azmi Sharom, or Doc as we call him, and together with Judge, they will be speaking on the topic of right to education. So before going into our discussion, allow me to first very briefly introduce our speakers. Judge is our keynote speaker. Judge graduated from the London School of Economics, and Judge has illuminated the judicial firmament for 23 years. Now, before retiring from the Court of Appeal on the 9th of September 2017, in his 23 years, Judge has delivered nearly 750 judgments at various levels and on various matters. Today, besides being a consultant for our firm, Judge is also the chairman of the Competition Commission of Malaysia, MYCC, and a member of the Human Rights Commission of Malaysia, UUCA. Our guest speaker, Dr. Azmi Sharom, or Doc, as it's called, does not require much introduction, much like Judge. He joined UM in 1990 and served as a lecturer in the law faculty until 2019. And whilst he was a lecturer, he also wrote for The Star. He had his own column called The Brave New World, which he wrote for over a decade. And I'm also told that whilst he was a lecturer, he was into amateur acting. And I'm also asked to say this, he is an avid Tottenham Hotspur fan. So in 2019, Doc joined the Election Commission as a deputy chairman, where he presently serves. So we are indeed honored to have you with us today, Doc. So without further ado, let me pass the stage on to you on the right to education.
Right, yeah. Thank you, Glenn. Thank you for that introduction. You obviously did quite a lot of detective work. The whole business of my thespian endeavors before you were even born, yes, everything else was accurate. Thank you to the firm for inviting me to speak. It's my pleasure, of course, to do this. It's an honor to share the same stage as Dato Seri, who, in my humble opinion, was the Chief Justice we needed but did not get. So thank you very much for this. Right, let me see how to begin. I haven't taught for 2 years, so I'm rusty. So forgive me if I'm worse than usual, but some things don't change. I don't use PowerPoint, I don't use computers, I write things on a piece of paper, and I still do. So let's look at this. So we're talking about the right to education. Yes, right to education. And what I decided to do was I wanted to quickly, before we go into our constitution, is just have a look at international law, because that's where I think we can establish the kind of standards and the kind of norms when we talk about right to education. What do we mean when we say a right to education? And I think the best place to look for that is not within the beautiful pages of our constitution, but in the bigger sphere of international law. So that's what I'm going to do. So I trust that some of the people who are listening might not be lawyers. Am I correct? Is this open? Okay, so for those who have done international law, forgive me for rehashing what you already know, but for the sake of everyone. So we're talking about international law. Basically, one thing we have to remember is you have what is known as soft law and hard law. Soft law are things like declarations. Okay, like for example, the Universal Declaration of Human Rights. It's a soft law. By this, it means that it's not legally binding on its signatories. It is merely a statement of principle, and the signatories are perhaps morally bound. But when have governments ever cared about morals? But anyway, they're morally bound, but they're not legally bound. So you can't bring them to court per se. Then you have hard law, which are treaty laws, and these laws are you sign it, you ratify ratify it, and these laws are meant to be legally binding, so almost like a contract between states. Okay, so first we've got to keep that in mind. There's soft laws, morally binding, hard laws like treaties, legally binding. That's the first point. Now, when we're talking about human rights, let's talk about human rights, the principle of human rights. Generally speaking, you can divide human rights to first generation rights, second generation rights, and third generation rights. Now, I'm not going to talk about third generation rights because what we're concerned with here is primarily first and second. First generation rights are what you and I normally think about when we think about human rights. I have freedom of speech, I have freedom of assembly, I have freedom of religion. You know, these are the things that you normally think about. And generally speaking, these kinds of rights, equality, fair trial, the obligation on the government of the day is to do as little as possible, in the sense that, for example, the less laws you have restricting my freedom of speech, the better it is, right? So, you're supposed to basically leave me alone, right? Okay, you're not supposed to interfere. You are not supposed to interfere in the process of fair trial, for example. You're supposed to let the judiciary do it. So it's also been, so these rights have also been, perhaps not accurately, but some have described it as having a negative obligation. The less you do, the better it is. So, you know, for example, you might say that the Peaceful Assembly Act is a bit too much. You're doing too much. Do less. Do less. Okay. So that's that. Now, second generation rights are slightly different, also known as economic, social, and cultural rights. These are not so much about the individual per se, but it's also about the community at large, the society at large. And this is known as placing upon the government a positive obligation. They have to do something. Now, what kind of rights are we talking about? So we're talking about things like the right to housing, right? The right to education falls under this category of rights. It's still a human right, okay? We're just categorizing it. And the right to health. Now, this is where the government has to be proactive. You cannot just tell us, you have a right to be healthy. Go and be healthy. You can't just tell us, be healthy. Oh, thank you. You have to do something about it. You've got to build a hospital. You know, you can't tell us, educate. You can educate. No, you have to give us schools. And you have to teach us in the schools, etc. Right? So they have to do something. Now, there's a difference between the two rights, because for second generation rights, let's be honest, some countries are richer than others and they can do more. So the demands on the government are slightly different, right? There's nothing stopping you from giving us fair trial. There's nothing stopping you from giving us equality, nothing stopping you from giving us free speech, except legislation, perhaps. But if you're not rich, maybe you're not able to give us the best hospitals. Maybe you're not able to build universities, right? So that's why second generation rights, it's a term right, it's progressive. Governments are encouraged to improve, but it isn't as black and white as say, freedom of religion, right? Those kind of rights, they don't have to, they don't spend anything. They just make sure they don't bother us, right? But the second generation rights, you have to do something, and some just can't because of their situation. So we've got to understand that. We have to keep that in mind. All right? You cannot go out and tell the Malaysian government, we want Oxford, Cambridge now. Will be hard pressed to find lecturers who can do it, but you know, nonetheless, you know, you can't have that kind of maybe or MIT, you know, the kind of money that they have to spend, all that kind of those considerations. So that's the general background. Sorry if I'm slower. Now let's look at international law with regards to right to education. Universal Declaration of Human Rights mentions it. Okay, in Article 26, and like I said, yeah, this is a soft law. It's a declaration. It's not a treaty. It's a soft law. But Article 26 says that everyone has a right to education. Primary education is free, should be free, right? Higher education should generally be accessible and based on merit. Now, this is quite general. This is in the Universal Declaration of Human Rights. It's a soft law, but Malaysia is morally bound to it by virtue of being a member of the United Nations. So let's keep that in mind. Okay, now let's look at something which is, oh, one more thing. Parents have a right to choose where their children go to school. So this is in the Universal Declaration, and it's quite general. If you read it, if you have nothing to do and you're bored and you read it, you'll see it's very general. Now let's look at something a bit more hard. In fact, it is hard. This is the International Covenant on Economic, Social, and Cultural Rights. Now, this is an actual treaty, right? And here they expand on what is already in the Universal Declaration. So, for example, very clearly, primary education is free and available to all. I just want to emphasize that. Free and available to all little kids. Secondary education must be made generally available, but if possible, move towards providing free secondary education. Higher education must be generally available based on capacity or merit. Again, have to move, if possible, move towards free higher education. Some countries have it, like Germany. And a few years ago, my God, a few decades ago, I remember some of my students, making calls for free higher education, and a lot of people say, "How dare you ask for free education?" Actually, it's not such a weird thing. It's actually an international ideal that free education all the way up to university is provided for. That's the three things. Furthermore, yes, according to the covenant, governments must try to improve the standards of schools, including the pay and the conditions of the staff. I should have used this when I was in university, when I was arguing with, about my awful pay. But anyway, too late now, too late. Again, parents are free to choose the schools that they send their kids to, but the government has the right to set standards for these schools. So it just cannot be any nonsense, right? Anyone can establish an education institution, but again, the state can establish standards. So this is the International Covenant. It has expanded on the Universal Declaration. Malaysia is not a party. We have not signed it, unfortunately. All right. But we have signed some things where education is mentioned. One of them is the Convention on the Rights of the Child. Now, the Convention on the Rights of the Child basically repeats what was in the International Covenant. Okay? It's the same, and now I'm not going to repeat it, with the addition of the dignity of the child must be protected. And I think what they're talking about here is punishment. So no more rotan, that kind of stuff. Again, I wish this was around in the 70s when I was in school, but unfortunately, I was rotan. So that's the addition. Is Malaysia a party to this? Yes, we are. And no, we're not, because this convention also requires free primary education for all. And Malaysia made a reservation for that particular provision. Okay, everything else, they go, yeah, that's cool. But no, free primary education for all, no, we don't want to do that. So a reservation in international law term means that they choose not to be bound by that particular section. Another thing which the Malaysian decided to be bound, if I'm not mistaken, is the torture of children. I don't know why, but anyway, so that's another story. Yeah. Convention on Rights of the Disabled, which we are party to. That one is actually, their section on education emphasizes, rightfully so, and understandably so, access. So that means that disabled must have access to institutions of learning. Okay, so these are the international laws which deal directly with right to education. Now let's move to our law, Malaysian law. If you look at the Constitution, Article 12 is where you go straight to talk about education, because it's one specifically, rights relating to education. And according to Article 12, there's no discrimination against any citizen, and here I underline citizen, the word citizen. Before, when I was talking about rights to education, it's all. But in our Constitution, it specifically mentions citizens. No discrimination against any citizen on the basis of religion, race, etc., place of birth, in the administration of any educational institution maintained by a public authority. In particular, readmission or payment of fees. So the administration of education, you're not supposed to be discriminated against. Also, when providing financial aid for the maintenance of education, there shouldn't be any discrimination there either. Okay, this is all in Article 12. All religious groups can set up their own education institutions. But here the government says that the constitution allows them to help with Islamic institutions. So I mean, if they wanted to, I suppose they can set up a seminary if they wanted to, but they don't, they're not bound to. But if they help the Islamic institutions, but not the Christian or Buddhist, it's okay because the constitution allows for it, right? So they can, in that way, they can be discriminatory, or more accurately, give people slightly different treatment. Okay? So that's with regards to Article 12. Or one more thing is you can't be forced to receive religious education other than your own. Right? So I could, when I was a schoolboy, I could be forced by my ustad to listen to him, but I cannot be forced by some pastor to listen to him. All right? And my ustad forced me along. Right? So that's all they have in Article 12. Now, please, what is missing there? There is no mention to a right to education. You have a right to not be treated unequally in the administration of education. But there is no right to education per se, or it's not mentioned specifically or expressly, right? So, so that is the issue. Now, realistically, if we look at Malaysia, let's be fair, primary education and secondary education is, if not absolutely free, is almost free, because there isn't fees per se in public schools. You have to pay the URA, which is basically about things like, Hari Bijaksana, or school magazines. You got to pay for these incidentals, but you don't have to pay a fee to go, to go to a government school. If you go to a private school, yes, you have to pay a fee, right? In order to get a schooling, but not government, and it's applicable to primary and secondary. Okay, and even the public universities are very heavily subsidized. So even though there are fees at that level, in all honesty, compared to private institutions and compared to overseas institutions, it's cheap. Okay, so let's be fair. But because the Constitution talks about citizens, and it doesn't even talk about a general right to free education for primary schools. The problem what we have here are undocumented children. And by undocumented children, we're not talking about foreign children, children whose parents were born in Malaysia, their grandparents, but they never bothered to register, for example. So these are undocumented Malaysian children. Without the documentation, it becomes a problem for them to go to school, right? Let alone children of undocumented migrants. Let alone children of refugees. So you have an entire class of young people, very young children, in fact, who will not get the basic skills needed for their future. And these are basic skills, right? And I get irritated about this because what you're doing is you're creating an underclass. And if there's anything which is going to cause instability in any society, is having an underclass. Right? So this is why education, definitely for primary and secondary, has to be free for all. Let me give you an example. If you were living in the UK and your child was to go to school, you just bring your child to the nearest school, and that's it. They don't ask for IC, they don't ask for birth certificate. Is this really your child? It's a child. The child deserves to go to school. End of story. All right? And that's what I dream that our country will be able to achieve. Okay, so that's with regards to that. There are other things like the elephants. Now, what elephant am I talking about? I'm talking about the elephant in the room. If you look at Article 12, it says, no discrimination, and I could actually feed it through the screen, right, through your viewers. How many do you have? 5?
Quite a bit.
Hundreds of viewers. Hundreds of viewers. Ask me, come on, man, what are you talking about? What about the universities? What about quotas? What about scholarships? Yeah, that's true. Article 12 says all this, but Article 12 is subject to Article 8. Article 8 is for equality, and Article 8 specifically says that when the Constitution allows for non-equal treatment, then non-equal treatment can occur. And what we're talking about here is Article 153. I haven't said those words in many years. It's been a long time since I have to talk about Article 153. But what we're talking about here is Article 153, which effectively allows for affirmative action or positive discrimination, whatever you want to call it, for Malays and natives of Sabah and Sarawak. And that is where you see the Constitution allowing for scholarships and even places, quotas, to be set based on race. Right? So yes, Article 12 says there's non-discrimination, etc., but Article 8 allows for it, and Article 12 is subject to Article 8 and Article 153. Okay, so that is where, before you get excited and say, oh, it's unconstitutional. No, I'm afraid quotas and scholarships and based on race is constitutional. We can talk about it more later, just how constitutional is constitutional, but I think one of your questions talks about that. I'm going to save it for you, Kuhan. I'm not going to make you look bad. I'm going to let you ask the question. All right. Okay. What else is there? There are related rights in. I'm almost done. There are related rights. You see, human rights, and this is something which I like to mention again and again. It's interrelated and it's interdependent. They don't stand by themselves. They're all interrelated. So there are issues, there are rights, there are articles in our constitution, which actually is related to education, even though the word education is focused. And I'm looking at here primarily, for example, language, right? And this is a cultural right. The right to teach any language that you want to teach is guaranteed by the Constitution. That's in Article 152. 152 says, even though Bahasa Malaysia is the national language, the right to teach any language that you want is, to speak any language that you want is a right. Right, so that's related to education because we have vernacular schools, Tamil schools, we have Mandarin schools, and if schools want to teach a particular language, it is their right to do so, right? But I think that's what you're going to be speaking about this. Exactly. So I'm going to leave all the really difficult, complicated stuff to Dato Seri, and I'm going to talk about the generalities. Now, what's close to my heart with regards to related articles in the Constitution related to education is Article 10, expression and association, because these two rights are intimately related to academic freedom. And academic freedom, of course, applies at all levels of education, but primarily to higher education, to university education. And you need academic freedom in order to really grow. You need academic freedom to have students who are critical thinkers, who are independent thinkers, to have academics, writers, who are willing to challenge the status quo, who are willing to look at things in a different way, to move forward, right? Without academic freedom, it's very difficult to achieve these things, all right? But academic freedom is curtailed because our freedom of speech and our freedom of association is curtailed by other laws. So even though the word education, you can't find education in Article 10. But Article 10 affects education very, very profoundly. And again, I think we'll be talking about this in the question and answer, so I'm going to leave it at that. So basically, that is the foundations. If you want to know what a right to education is, look at the international laws. It lays it out very nicely, particularly in the International Covenant on Economic, Social, and Cultural Rights. And in Malaysia, we have Article 12 of the Constitution and a few other related articles. But what we have to remember about Malaysia is that there isn't a right to education per se, only a right for there to be non-discrimination in the administration. So I think with that, I'm going to stop and leave it at that.
Thank you, Dr. Azmi. So we'll now hand over to Judge. But before I hand over to Judge, just a quick reminder, if any of you have any questions that you would like to ask to either Doctor or Judge, then please just put it in the Q&A box or in the comment section, and we will then direct your question to them. If you want to ask both of them, then just put it there and specify the one. So without further ado, I'll now hand over to our keynote speaker, Judge.
Thank you, moderator, Mr. Kohan. Salam sejahtera and good afternoon to all members of the audience. Welcome to our webinar. To my learned and good friend, Dr. Azmi, thank you for being with us this afternoon to share your thoughts and knowledge on this interesting subject of fundamental rights to education. Now, a right to education is a fundamental right under our federal constitution and is housed under Article 12. Yeah, as mentioned by Dr. Azmi, it is also a human right and reflected in Article 26 of the Universal Declaration of Human Rights and Article 13 of the International Covenant on Economic, Social, and Cultural Rights, which we are long overdue to be a member, to be a party. Now, for the purpose of this afternoon's discussion on my part, as I've discussed with Dr. Azmi, I'll be taking an approach different from that he has taken, and I'll be taking a case law approach. I'll be discussing 3 cases. These cases have relevance to education under the federal constitution. And these cases in chronological orders are the Medical University case, it's a 1982 case, the UKM4 case, UKM stands for University of Malaysia, 4 stands for the 4 students involved, and it's also known by the name of case of Muhammad Ilman Idam and 3 others. It's the 2011 case. And finally, I discussed the Tamil school discrimination case. It's a 2013 case. Apart from the Medical University, the other 2 cases are cases which I presided while at the current review. Right. I shall begin with the first case, the Medical University case. This case concerns the right of the citizens to establish a private university. Although the case concerns the right to education, however, the facts and issues revolve more on Article 152 rather than on Article 12. Unfortunately, in my respective view, the High Court and the Federal Court judgments were not as expected. Disappointing. In fact, in this case, the judgments attract criticisms and from legal scholars. First, a little bit of background. Article 152, Clause 1 declares Malay as a national language. Nonetheless, Clause 1 permits the use of other languages as long as such other languages are not used for official purposes. Now, after Merdeka, there was a move towards the establishment of Bahasa Malaysia as a de facto as well as a de jure national official language. Bahasa Jiwa Bangsa. Be that as it may, Article 152 Clause 2 allowed English to be used in parliaments for the transitional period, allowed to be used in parliament, in state assemblies, and for official purposes for 10 years after Merdeka, until parliament otherwise provided. No, until parliament otherwise provided. So, in 1967, our parliament so provided. Parliament passed the National Language Act of 1967, and under Section 2 of this Act, from 1st September 1967, the national language is to be used for official purpose. Then something more important happens. In 1971, the Universities and University Colleges Act, UUCA, was enacted and provisions were made, among others, for the procedure to be complied with in establishing any university. Section 5 of the Act provides that no university may be established except in accordance with the provisions of the Act. Section 6, which is the important section for purposes often reads. Clause 1, subsection 1 of Section 6. If the young Lieutenant Agung is satisfied that it is expedient in the national interest that a university should be established by order A, declared that there shall be established a higher educational institution having the status of a university. It must be pointed out that even if permission is granted to establish a private university, wide powers are given to the executive, meaning the government, under the Universities and Colleges Act with regard to certain important aspects of university life. For example, the young Diputan Agong is given power to assign the name of the university, specify the location of the site, which shall be the seat of the university, assign the faculties of the university, the departments, and prescribe such other matters as may be necessary or expedient. By virtue of Section 8 of the Act, all universities, whether private or otherwise, must contain provisions for all matters set out in the model constitution as specified in the schedule to the Act. Under the constitution, the young Diputan Agong, and this is a very important provision, very important power, the young Diputan Agong, meaning the government, means the government, has the power to appoint the chancellor and the vice chancellor of the university. As you know, the vice chancellor is most important, the most powerful man in the university. It would therefore be clear that a private university, as contemplated by the Universities and University College Act, cannot be considered to be a truly independent university in view of these wide powers and the control which is given to the government. The scope of this provision was considered by the High Court and the Federal Court in the case of Merdeka University Berhad against Government of Malaysia. In the case of Merdeka University, the Federal Court had to resolve the conflict between the right to use languages other than Bahasa Malaysia, for example, the right to use Mandarin in education, and the duty to use the Malay language for official purposes. Now I come to the facts of the case. A company called Merdeka University Berhad, supported by many Chinese guilds and chambers of commerce, submitted a petition to the Agong under Section 6 of the UUCA to set up a private university called Merdeka University. For this university, Mandarin would be the medium of instruction. The government, however, refused to give permission for the establishment of the university. The reason given is that the proposed university, since it is intended to use Mandarin as the medium of instruction, would conflict with the national education policy. And this refusal was challenged in judicial review proceedings, partly on the ground of contravention of Article 152, Clause 1 of the Constitution. We will recall that Clause 1 of Article 152 guaranteed the right to use or to teach any language other than Bahasa Malaysia, and not this caveat, as long as the use of that language is not for official purposes. So let us now examine Article 152. Article 152 Clause 1 provides that Malay shall be the national language, but it immediately goes on to provide as follows. A, no person shall be prohibited or prevented from using otherwise than for official purposes or from teaching or learning any other language. And B, nothing in this clause shall prejudice the right of the federal government or any state government to preserve and sustain the use and study of the language of any other community in the Federation. Thus, it will be noted that under Article 152 Clause 1, the use of languages other than national language is permitted, but these other languages, such as Mandarin, cannot be used for quote, official purposes. In the Merdeka University case, the question arises as to whether, assuming the Chinese language is used as the medium of instruction of the university, does it amount to using Mandarin as an official purpose? In order to answer this question, the Federal Court proceeded to find out the meaning of official purposes, since this term appears in Link A of Clause 1 of Article 152. The term official purpose, however, is defined in Clause 6 of Article 152 as follows. Quote, any purpose of the government, whether federal or state, and includes any purpose of a public authority. Obviously, the purpose of the proposed medical university is not any purpose of the government, but it is meant to be a private university. Therefore, the question then arises as to whether the proposed medical university would be a public authority. The answer to this question is crucial. This is because if the proposed medical university is a public authority, then using Mandarin as a medium of instruction of the university would amount to using Mandarin as an official purpose. And this is prohibited by Clause 1 of Article 152. It follows then that the question now is, what is a public authority? The answer to this question is crucial because if the proposed medical university is a public authority, then the university is prohibited by Article 152 from using Mandarin as the medium of instruction. Under our federal constitution, the term public authority is so defined in Article 162, Clause 2, as to include a statutory authority exercising powers vested in it by federal or state law. Unfortunately, the majority of the federal court held that the proposed medical university would be a statutory authority exercising powers vested by federal law, and therefore the medical university would be a public authority by definition. That being the case, the proposed medical university could not use Mandarin as a medium of instruction. The federal court then proceeded to rule that the decision of the federal government in rejecting the medical university Berhad's petition to establish a private university was constitutional and lawful. Lord President Tun Sufyan, in reading the judgment of federal court held, I quote it, a university established under the Act, even if private, clearly has the requisite public element, as is subject to some degree of public control in its affairs and involves a number of public appointments to office in its framework, acts in the public interest, and is eligible for grants in it from public funds. Close quote. At the federal court, however, one of the judges, Justice Dato Seri, dissented. He held that a university incorporated under the UUCA would not be exercising governmental or quasi-governmental powers vested in it by federal law. Therefore, according to his views, such a university would not be a public authority. This means the proposed medical university would not be a public authority within the meaning of the definition in Article 160, Clause 2. And not being a public authority, the proposed university could lawfully use Mandarin as its medium of instruction. On my part, I prefer the minority judgment of Justice Dato Seri. I respect to submit that the decision by the majority was unfortunate and incorrect, as it prevented a minority group from using its language for educational purposes. Secondly, the majority judgment confuses public authority exercising statutory powers with a private body exercising private rights but subject to statutory control by a public authority. The only possible public element here was the fact that education is a public function. However, it is possible for a private body to provide a public service without itself becoming a public authority. The result of the case is that a narrow interpretation is placed upon the language rights in Article 152 Clause 1, and the linguistic rights of minorities are correspondingly reduced. We shall now leave the Medical University case and come to the second case, the UKM4 case. This case concerns the right to free speech of university students. I've chosen this case as one of the cases for discussion this afternoon because the right to free speech of students and the right to education are closely linked, as mentioned by my learned friend, Dr. Azmi just now. To deny students the right to free speech is tantamount to denying them of their right to proper education. In other words, university education is meaningless and a farce if students are not free to think and to speak of their minds. Let me relate to you briefly the facts of the case. This case concerns the notorious University and University College Act of 1971. From now on, I'll refer to this act as the UUCA. The objective of this act was to curb student activism, to restrict and weaken organized students' movements. As a result of the UUCA, students' activism dwindled in the 80s and the 90s. Now, Limb A of Section 15, Subsection 5 of the Act prohibited UC students from exercising or doing anything which may reasonably be construed as expressing support for or sympathy with or opposition to any political party. So find out whose brainchild is this, yeah? The appellants, Muhammad Hilman and 3 others, were political science students at UKM. Sometimes in April 2010, they were present in the parliamentary constituency of Pulurangan in the campaign for a parliamentary by-election. They were there merely to observe the by-election. Subsequently, however, they were charged by the University Tribunal for breaches of disciplinary offences under Limb A of Section 15, Subsection 5. In the disciplinary proceedings, they were alleged of being in possession of paraphernalia that was supportive or sympathetic or in opposition of contesting political party in the Hulu Selangor parliamentary by-election. Now, before the Court of Appeal, before my panel, the appellants argued that Link A of Section 15, Section 5 of the Act is unconstitutional, for it restricts the right to freedom of speech guaranteed under Article 10, Clause 1, Link A of the Constitution. The university and the government, the associate respondents before the court, on the other hand, argued that the restriction on the students' freedom of speech is necessary in the interest of public order and morality, thus permissible under Clause 2, Limb A of Article 10 of the Federal Constitution. At the Court of Appeal, it was decided between the 3 judges, the 3 of us on the panel, that we wrote separate judgments. So each of us wrote separate judgments. As it turned out, on the day when each of us read out the judgment in open court, that it was a split judgment for the Court of Appeal. Before this, we never show each other how our judgment is going to be. Keep it to our shared secret. Yeah. Justice Linton Albert and I formed the majority judgment. We allowed the appeal by the student, that is the appellants. While Justice Lau Beng, who chaired the panel, delivered a dissenting judgment and found for the government and the university. We, the majority, found Limb A of Section 15, Clause 5 of the Act to be an unreasonable restriction on the freedom guaranteed by Article 10, subsection R, clause 1 of the Constitution. And so deciding, we apply the Federal Constitution of Civil Rasa against Badan Program Malaysia. We have that the word reasonable should be read into the restriction or derogations permitted by clause 2 of Article 10. In my separate judgment that I delivered, I say I was of the view that a student who expressed support for or in opposition against the political party could not be seen to harm or bring about an adverse effect on public order or public morality. This is because political parties were legal entities carrying out legitimate political activities. I pointed out that political leaders include ministers and members of the federal and state legislatures who are members of political parties. I further pointed out in my judgment that most university students were of the age of majority and could enter into contracts and sued or be sued. They could marry, become parents, and undertake parental responsibilities. They could vote in general elections if already 21 years old. They could become directors of companies and office bearers of societies. Yet, and herein lies the irony, they are now told by Lingi of section 15, section 5, that they could not say anything that could be construed as supporting or opposing a political party. I have the Lingi of section 15 of section 5 of the UCA absurd and irrational. I further said in my judgment that the impugned provision impeded the healthy development of the critical mind and the original thoughts of students. Objective that seats of higher learning should strive to achieve. Universities should be the breeding ground of reformers and thinkers, and not institutions to produce students trained as robots. The impugned provision clearly was not only counterproductive, but depressive in nature. Following the majority decision of Muhammad Hillman, that section 15, subsection 5, link A of the Act violated Article 10 and therefore void the government in a rare move. The government in a rare move acted positively by passing the University and University Course Act Amendment Act of 2012 to amend section 15 of the Act. In the explanatory statement to the Act, to the UUCA amending bill, the government acknowledged and accepted the judgment of the Court of Appeal in Muhammad Hillman. Accordingly, the UUCA Amendment Act repealed those parts of section 15 that prohibit students from uttering any statement in support of or in opposition to any political party. In fact, the amendment went even further. The amending legislation now allows students to be members of political parties. Subsequently, other identical provisions in the Private Higher Education Institution Act 1996 and the Educational Institution Discipline Act 1976 were amended to keep in line with this decision. A student's right to association and freedom to express his support for political parties is no longer stifled by draconian laws. I come now to the last case this afternoon, the Tamil school discrimination case. This is a case of Manohara Malayalam again and another again, Dato Seri Hishamudin and others. This case concerns a complaint of nationwide discrimination against Tamil primary school, National Tamil School, by the federal government in terms of funding assistance and the welfare of the school. The plaintiffs were Mr. Manohara and Mr. Uthaya Kumar. They were advocates and solicitors. At the point of time, Mr. Manohara was also an assemblyman of the State Legislature of Selangor. They alleged that the Tamil schools were being discriminated by the government in violation of Article 8 and Article 12 of the Federal Constitution. They alleged that Tamil schools were only being given a nominal financial assistance, unlike other national schools that would be given full financial assistance. The buildings of the Tamil school were poorly maintained and the classrooms were overcrowded. The plaintiff thus commenced an action seeking, among others, number one, a declaration that the practice of providing nominal financial assistance to the Tamil school were in violation of Articles 4, 8, and 12 of the Constitution, and secondly, a declaration that the operations of the Tamil schools in dilapidated and termite-infested pre-independence buildings that are safe for occupation and in overcrowded classrooms were contrary to Articles 8 and 12 of the Constitution. This action was, however, never made it to trial. It was struck out by the High Court on the sole ground of Locust Standard. The High Court ruled that the plaintiff's right and interest have not been adversely affected. None of the plaintiffs had children at Tamil school. Nor did the plaintiffs, Mr. Manohara and Mr. Uthaya Kumar, claim that they were Tamils. At the Court of Appeal, we took a different view from that of the High Court. We held that the plaintiffs were complaining about the violations of the Federal Constitution by the federal government. Therefore, as citizens, they had the Locust Standard. We had a precedent in so holding, and that precedent is the case of Robert Lingi against the government of Malaysia, which concerned an allegation of breach of the Federal Constitution by Parliament. In this case, the plaintiffs sought the following declarations. A, that the removal of judicial power from the High Court of Sabah and Sarawak by virtue of the amendment to Article 121 of the Federal Constitution is null and void. B, that the removal of the power of appointment of judicial commissioners to the High Court of Sabah and Sarawak by the Yang di-Pertuan Negeri of Sabah and Sarawak is null and void. And finally, C, that the setting up of the Judicial Appointments Commission under the Judicial Appointments Commission Act of 2009 is unconstitutional and hence null and void. Like in Manohara's case, in Robert Lingi, the issue of Locust Standard was also raised by the government. Since Mr. Robert Lingi, the plaintiff, was merely a Malaysian citizen of Sabah origin, and there was no dispute that the plaintiff's rights were not affected by virtue by the amendment to the Constitution. But the High Court in Robert Lingi rejected the contention of the government of Malaysia and went on to hold, if I may be permitted to quote the learned judge, Justice David Wong, who later became the Chief Justice of Sabah and Sarawak. This is what the learned judge said. The plaintiff, as a Sabahan, in my view, is genuinely concerned with the erosion of the rights of Sabah insofar as the Constitution and jurisdiction of the High Court of Sabah and Sarawak and the appointment, removal, and suspension of judges of that court, and since it concerned an attempt to uphold the Federal Constitution, I have no hesitation in finding that the plaintiff has the Locust Standard to bring this action. I am fully aware of the argument that this may encourage litigation, but in my view, when there's a challenge concerning any dismantling of the supreme law of the country, litigation should be encouraged. In any event, all Malaysians have a duty to protect our constitution, unquote. The High Court Robert Lingi found considerable support from two foreign cases, the one of the only mentioned one. One of which is the case from Tanzania. This is the Tanzanian High Court case of Reverend Christopher Tikila against the Attorney General. In this case, it was held, permitted to quote again, in matters of public interest litigation, this court will not deny standing to a genuine and bona fide litigant, even where there's no personal interest in the matter. Given all this and other circumstances, if there should spring up a public spirited individual and seek the court's intervention against legislation or actions that pervert the constitution, the court, as guardian and trustee of the constitution and what it stands for, is under an obligation to rise up to the occasion and grant him standing. The present petitioner is such an individual. Close quote. In Manohara, after referring to the judgment of Justice David Wong, we unanimously ruled as follows. And I delivered the judgment of the court. I said, quote, on our part, in the context of the present case, we prefer to adopt the approach as taken by David Wong J, as he then was in Robert Lingi, that in the case where the complaint of the plaintiff is that the federal government or its agent has violated the federal constitution by its action or legislation, he has a locus to bring an action to declare the action of the federal government or its agent as being unconstitutional, without the necessity of showing that his personal interest has been adversely affected. The approach that we now take is essential if the constitutional principle that the constitution is the supreme law of the federation and that the courts are the protectors of the constitution are to have any effective meaning. In other words, what we are ruling is to the effect that in a case where the complaint of the plaintiff is that there has been a violation of the constitution by the federal government or its agency, the Lim Kit Siang principles on Locust Standard do not apply. The legal position housed under Manohara continues to be approved and adopted by the following judges. First, was adopted by Justice Lee Swee Seng in Indira Gandhi against Pengarah Jabatan Agama Perak. The decision of Lee Swee Seng JC was accepted by the federal court in Indira Gandhi against Pengarah Jabatan Agama Islam and others. Secondly, it was adopted by Chief Justice Tengku Maimun in the federal court case of Dato Seri Hishamudin Yunus against Government of Malaysia at page 154 of the judgment. It is a dissenting judgment of her ladyship. Our ruling in Manohara was also adopted by David Wong, Chief Judge of Sabah Sarawak, in Dato Seri Hishamudin case, also in his dissenting judgment. With that, I end my presentation. Thank you for listening. I'll be happy to hear questions from the audience if there is any. Thank you.
Thank you, Judge. Thank you. So now, before I open up the questions to the floor, I've got a few questions to bring up. So the first one is in results of the pandemic that we recently, or we are still going through. Now, because of the pandemic, classrooms have moved on, and they have, and this in turn has exposed inequalities in our society between those who have and those who don't. So in light of this pandemic, how has the role of government changed in regards to federal constitution? Prof, you want to start off?
Yeah, like I said, in my point of view, Article 12 doesn't guarantee a right to education. Article 12 guarantees a non-discrimination education administration, but it doesn't expressly state that everybody has a right to education. However, if we look at it from a larger perspective, education is a right, and definitely for primary children and secondary. This being the case, the government is bound, right, to provide the necessary tools with which students can obtain an education. In times of normal times, it means schools. It means school buses for those who cannot afford it. All right. But in times like now, it means connectivity. It is a responsibility. I'm sorry. I mean, it's your responsibility to provide education. If it means providing laptops and similar devices, then that is what has to. That's what we have. I appreciate some countries are very poor, but I don't think we are that poor. I mean, we could renovate buildings and things like that. I'm sure we can afford to, Anyway, yeah. So that's my point. It's a responsibility. You have to.
Thank you, Judge.
My response will be more or less on the same line as Dr. Azmi. Yeah? Now, talking about inequality, inequality in our society between the haves and has not were already there even before the pandemic. This includes inequality even in the field of education. But the COVID-19 pandemic, physical classes are for the time being not possible. So teaching and learning has to be online. Online teaching and online learning requires computers and internet connections. But students whose parents are poor may not be able to have computers, and students living in the remote areas may not have access to internet. Thus, the inequality between the rich and the poor, between the urban and the rural, becomes all the more greater. Now, in order for government to discharge its constitutional obligation under Article 12 of providing education without discrimination, it faces greater challenges with the pandemic. More resources, especially financial resources and planning, needs to be put in order to discharge that constitutional obligation to provide education to the citizens equitably. For example, the government must endeavor to provide computers to the poor students. The government must endeavor to provide internet access to the students living in the remote areas. The efforts must be real and sincere efforts. No flip-flop policies. The education department must be given an allocation bigger of the nation's budget than previously. These are constitutional obligations mandated by Article 12 of the Federal Constitution. Thank you.
Thank you, Judge. Now, we'll stay on the theme of COVID-19. If a student refuses to be vaccinated, can he or she be denied their right to attend school?
Yeah, that's actually a quite tough one. Because, I mean, I would argue that in the interest of public health, which is the legitimate interest, then I think rules such as the requirement of vaccination before one can attend public institution like a school is reasonable. I mean, we're doing it now. Even in private institutions like a restaurant, if I'm not fully vaccinated, I can't go in. So it's difficult because there is a conflict, there is a tension between the freedom to, whether you choose to be injected with something or not, and your right to go to school, right? So there is a tension, but I think in the interest of public health, it's perfectly right. I mean, it's my right to travel, it's my right to move around, but if I don't have a driver's license, it is not my right to travel.
Thank you, Doc. Yeah.
I might think it's only a different provision. At the moment, vaccination is not legally compulsory. It's not legally here. It's not legally compulsory. And when it's not legally compulsory, it creates problems. COVID-19 vaccines are, however, encouraged, meaning that if a person refuses to be vaccinated or refuses to have his child be vaccinated, then he will be subjected to any legal penalties. But as in May, it's good to see the government's campaign to encourage the citizens to come forward to be vaccinated is bearing fruits. A big percentage of the citizens are now vaccinated. But we still read in the media of citizens, including teachers, who refuses to be vaccinated. They may have their own reasons. Some of the reasons could be due to ignorance, or could be due to being susceptible to wrong advice from friends, family members, or religious preachers. Nevertheless, the government must step up its campaign relentlessly to educate the public. Where a citizen refuses to be vaccinated for reasons best known to him, the likelihood that he will not allow his school-going children to be being vaccinated as well. In my view, as long as there is no law to make vaccination mandatory, a student who refuses or is not vaccinated cannot be denied access to a government school, to a university. There will be unlawful discrimination. That would be, to my mind, there will be unlawful discrimination. That would be a violation of Article 8 and Article 12. In order to solve this problem, especially where in lot of public health necessitated by public health, because of public health, I would urge that the government to pass a law to make vaccination mandatory in law. Yeah. So otherwise, a person could argue that to force me to be vaccinated in the absence of a law is a violation of my body. Body autonomy. Thank you. Yeah, it's violation of body autonomy. Yeah. Yeah. But Article 5 says no person shall be deprived of his life or liberty, save in accordance with the law. So the government must use that. Save in accordance with the law. So pass a law. So when the government pass a law, I think a lot of problems could be solved.
Thank you, Judge. We will move to, I suppose, a question that has always crept up from time to time, especially during elections. It's not 153 yet, you can pick, but vernacular schools. Now, this is a two-part question. The first part is, are vernacular schools constitutional?
Due to the judge.
Okay. I'll begin first. Yeah. There are two parts of the question. You asked me the first part, do you? Okay, the first part. Whether vernacular schools are constitutional. I think I can answer this question fairly. Yeah. Second part is tricky. In my opinion, the establishment of vernacular schools are constitutional and are protected by Article 152, Clause 1(a) of the Federal Constitution, even though the medium of instruction will be, for example, Tamil or Mandarin. This is because vernacular schools, when by the American University case, vernacular schools are not public authorities. Hence, using Mandarin or Tamil as a medium of instruction in the schools will not be for official purposes. As long as use of Mandarin or Tamil in such schools are not for official purposes, that is, official purposes as understood in the context of Article 152 Clause 6, then the establishment of such school is constitutional, is a constitutional right under Article 152 Clause 1. Yeah, that's my take on the first one.
I concur. Please, let's move on.
The second one. Now, constitutionally, is the government's refusal to recognize the UEC certificate, which comes from the Chinese school, is that a breach of the federal constitution? They've gone to the Chinese school, they've gotten the education, now it's time to get a job. I cannot because the government doesn't recognize it. Is that a breach?
I think it would probably be a breach under Article 8. Because of equality. I think, all right, to be honest, I think I stopped reading the questions at this point, so I'm not totally prepared. But I would say that there is a possibility, there's an argument to be made that standards must be applied with regards to the recognition of any education project, right? So even universities, you have your bodies. So if a certificate what you're talking about has gone through that process and has satisfied, then just because it's in a different medium, I don't think we can discriminate against that, right? So I would argue that as long as the necessary standards of education is achieved, then it doesn't matter what medium diploma was obtained in, and it should not be discriminated against. I would say I would fall back to Article 8 and perhaps not Article 12, but definitely.
I'm quite close to that.
I haven't.
Well, on my part, I do not have a really yes or no answer. And I need to know more about the syllabus and subjects for this vernacular schools. Besides, I'm not an education expert. In my view, however, just because the establishment of Chinese vernacular schools are constitutional, it does not necessarily follow that the government must recognize the UEC. There's a need to evaluate educational standard of the UEC. In my view, there must be an independent body to evaluate the UEC without any bias or discrimination. The independent body must comprise experts in education and experts in constitutional law, as opposed to politician. The criteria that is adopted for conferring recognition to other school certificate for the purpose of evaluating whether or not to recognize the suitability of that certificate must be applied equally in evaluating the UEC. There cannot be different standards. The evaluation must be honest and must be based on Article 8, Article 12, and Article 152 of the Constitution. Political consideration should not come into the equation. Let it be known that at the moment, there are 100 foreign universities from 12 countries that have recognized the UEC. These countries include Australia, United Kingdom, Canada, Singapore, and the USA. It is puzzling why Malaysia is not recognizing the UEC. Minister Yang Berhormat Masli Malik, the Minister of Education, during the Pakatan Harapan government, is reported to have stated that one of the reasons that the PH government was having difficulty in recognizing the UEC was because, quote, yeah, recognizing the UEC was a sensitive issue because it concerns the history of the nation. Close quote. With respect, I do not think that is a valid reason for not recognizing the UEC. Thank you.
Thank you, Judge. So I'll move on to questions from audience. We have one from Firdaus Husni. So, and her question is directed to both speakers. So, in light of the status regarding the right to education in our constitution, what is your view regarding the ongoing case in Sabah, where a former student sued their teacher for failing to turn up in class to teach for 7 months? What's your view on that case? Let's go first.
Oh, that's a tough one. Is there a cause of action? Well, yeah, I read about that case quite some time ago, and then it totally went off my mind. Did it went to the court? I have no idea. Yeah, but well, what is the cause of action? Is it against the teacher or the school?
I believe it's against the teacher and vicariously liable the school.
Is there the issue here is probably is there a cause of action? It cannot be in contract, not going to be in tort. There could be a cause of action, but I'm just surmising it could be a cause of action under the Constitution, a right to education. And the teacher is absenting himself, so depriving the student right to education. So I believe he must have made the government as well a party to that. Must be, yeah.
School has been named.
I think that is the best. I'm not sure what is the real cause of action as reported, but I can only guess that it must a good cause of action would have to be based on the Constitution, Article 12, right to education, right to education. Yeah, suppose for Dr.
Yeah, I mean, this is Firdaus' tweet.
Yeah.
She's my ex-student, so she bothered me when she was a student. Now she's bothering me even after she's finished. I would agree with Dr. Seri. Personally, and I could be wrong on this, yeah, but like I said, my concern with Article 12 is the lack of an express statement that you have a right to education. If it was there, then it's clear. Now, purely on my opinion, of course, every single student deserves to get an education of a certain standard. If a teacher is not there, then the standard cannot be achieved, right? So that it goes without saying. But I would agree with Judge. What's the cause of action? How are you going to frame your challenge with regards to this matter? Frankly, there are many students, many teachers of mine. In fact, I think a lot of my students would be quite happy if I didn't turn up. But that's a different story altogether.
We will take one more question. We're already running out of time. Seems to be quite a popular topic. So, with regards to, and everyone is asking questions about 153 and the so-called right to education. So, I will leave it to you to say your piece on it.
I'll quickly then leave the last word to Arif. Okay, now this is interesting because it's interesting for two reasons. One, specifically because we're talking about in context of education, correct? So we're talking about scholarships and quotas. Yeah? Basically, that's it. That's the main contention. And it's in Yang Arif just now mentioned that in the UKM4 case, in their judgment, they said the word reasonable should be read into restrictions allowed by Article 10 of the Federal Constitution. So that means you should read into it. Article 153 already has the word reasonable in it. You don't have to read into it. It's there. Article 153 has two words, which many people seem to have totally misunderstood or ignored. One, necessity, and two, reasonableness. Both these words are specifically in 153. All right? So that means that the actions taken as allowed by under Article 153 has to be because it is necessary and it has to be done reasonably. Now, what is necessary and what is reasonable in Malaysia? I don't know. All right, these are concepts which float around, which people don't want to grasp. So unfortunately, for me, as a simple person, I have to go and look elsewhere to try to determine what is reasonable in this context. And most appropriately, the case that I go to is a case about education, although it's heard in the European Court of Human Rights in 1968. All right, and this is a Belgian linguistic case. All right, and in this case, basically, it's about, in those days, Belgium, depending on which part of the country you're in, the schools are in different languages. So it could be German, it could be French, it could be Flemish. All right, and this is about some parents saying that we are French, but we're not living in a French school area, but we want our children to be taught French. Sacre bleu, whatever it is they say in French. Right, okay, so that was basically what the case is about. I'm not interested in that. The decision of the case said that, yes, in Belgium, things are that people are treated differently, but you can treat people differently as long as certain criteria is met. First, there has to be a clear purpose. Why are you doing this? It has to be clear. Secondly, it has to be proportionate. If there's an issue, if there's a problem, and you're trying to solve it by treating people differently, it has to be proportionate to the issue. It has to be proportionate to the problem. It cannot be over the top. All right. Thirdly, democratic principles apply. What does this mean? This means that we have the freedom of expression, we have the right to question whether the purpose is clear or not. We have the right to say whether it's proportionate or not. Are the actions that you're taking here proportionate or not? That is the problem. The problem in this country is not that affirmative action is allowed per se. The problem is that we are not allowed to question whether it is proportionate, whether it is necessary or not. And really, we have to be able to do so because the Constitution says that it has to be necessary and the Agong can take the measures needed if reasonable. These two words are there. How do you know what's necessary? How do you know what's reasonable if you're not allowed to talk about it? If you're threatened with all sorts of crises, if you're not allowed to talk about it. And that for me is the problem because we are not talking about this issue in a rational, non-political, non-nonsensical, non-hysterical manner. And that's what we need to do. These things still exist. Do they exist? To what extent do they exist? And are they necessary today or not? That's what we have to discuss. I've got no problems with treating people differently, right? Because sometimes, no, look, there's equality, kind of like a formal equality, and there's substantive equality. All right. And in order to achieve substantive equality, sometimes you have to treat people differently. Okay, women, for example, CEDAW states that 30% of MPs should be women. It's not even close of that in Malaysia, right? And why? Because there's so much disparity. There has to be, but once it's achieved, it has to stop. And that's the point here. Once it's achieved, it has to stop because the fundamental principle which we must uphold is equality. So that's my piece. It's been my piece for years.
Thank you, Dr. Judge.
I'll take a different approach here. Yeah. On Article 153, why do we have Article 153 in the Federal Constitution, right? To begin with, our founding fathers believed in the principle of equality and the rule of law. So they inserted in the Constitution Article 8 and Article 12, these two clauses of non-discrimination in policies. But then they also inserted into our Constitution Article 153, providing for special treatment in respect of education for Malays in terms of scholarships and places in colleges and universities. This, on the face of it, is a breach of the equality principles. So how do you reconcile Article 8 and Article 12 on the one hand, and Article 153 on the other hand? In order to know the answer, we have to read the report of the Reid Commission. According to the Reid Commission, the terms of reference of the Commission requires the provisions be made in the Constitution for, I quote, safeguarding of the special position of the Malays and the legitimate interests of the other communities. Now, the Reid Commission report states that it found it difficult to reconcile these terms of reference with the equality principles. In the words of the Commission, I quote here, we found it difficult, therefore, to reconcile the terms of reference if the protection of the special position of the Malays signified the granting of special privileges permanently to one community only and not to the others. This difficulty of giving one community a permanent advantage over the others was also realized by the Alliance Party led by Tunku Abdul Rahman. The Alliance Party submitted its memorandum to the Commission, I quote, yeah, in an independent Malaya, all nationals should be accorded equal rights, privileges, and opportunities, and there must not be discrimination on grounds of race and creed. And the same view was expressed by the Malay rulers in their memorandum, in which they said, quote, that they look forward to a time, not too remote, when it will become possible to eliminate communalism as a force in the political and economic life of the country. The Reid Commission then went on to explain that the granting of special preferences to the Malays was rooted in history. Such special position for Malays could be found in the treaties which the British had with the Malay rulers. This special position for Malays was also reflected in the Federation of Malaya Agreement of 1948. On the matter of education, the Reid Commission made a finding. I think this is important. I quote, in many classes of scholarships, bursaries, and other forms of aid for educational purposes, preference is given to Malays. The reason for this appears to be that in the past, higher education of the Malays has tended to fall behind that of the Chinese, partly because the Chinese have been better able to pay for it, and partly because it is more difficult to arrange higher education for Malays in the country than for Chinese in the towns. The Reid Commission then proceeds to recommend as follows. Our recommendations are made on the footing that the Malays should be assured that the present position will continue for a substantial period. Not it's for a substantial period, not perpetually, for a substantial period. But that in due course, the present preference should be reduced and should, this is important words, should be reduced and should ultimately cease, so that there should then be no discrimination between the race or communities. I would like to add here that in a matter in the implementation of Article 153, the government at times shouldn't be extreme in the implementation. Like what Dr. Azmi said, should be proportional. Proportional. I take the view that to have Bumiputra only educational institutions at whatever level is against the spirit of Article 8, Article 12, and Article 153 of the Federal Constitution. You can have institution exclusively for Bumiputra to the exclusion of others. That would be unconstitutional and against the spirit of national harmony and national unity. Such Bumiputra only institution must open up for the intake of non-Bumiputras. Likewise, in the case of quotas for university intakes, I feel that a 10% quota for non-Bumiputra is too little, considering the population of non-Bumiputras. This quota must be increased proportionally. Thank you.
Thank you, Judge. And thank you, Doc. So that is all the time we have for this talk on the right to education. Again, take this time to thank both Doc and Judge for speaking to us on this topic. We also like to thank the audience for joining us today. Stay tuned for on our social media page for our upcoming talk on judicial activism. The details will be, you can find the details there. Thank you.
Thank you, Doctor. Thank you.
No, thank you. It's great. It's so